Hey there.
Do we have time today?
Yes, we have to go over stuff.
No. Mine was about Manny Aurora.
Oh, I haven't seen. Is that an email or a text?
A quick text, instant message thing. If not, it's okay. You can move on to somebody else.
How long do you think the sentencing hearing will last?
I've spoken to Ms. Green. I know that the state's presentation isn't going to last long, but I believe Ms. Parks has some individuals.
Oh, I'm sure, and I don't want to shortchange anyone. So we'll take as long as we need. If someone wants to get sworn in, and so if we finish in time, then we'll do that. But I don't. If you say I need 3 hours, you need 3 hours.
No, Your Honor, we won't need that long. I would say maybe an hour.
Okay.
If that.
11:30, if they can do that. Yeah, if not.
If not, move on.
Yeah.
Okay, thank you.
One more second. Mr. Jordan, if you don't mind, if you can either adjust that monitor or sit so Ms. Rivers can see you, well, it's fine for you to stand, just rotate that so you are displayed. That way Ms. Rivers can see you. Okay. Are you all right? You seem, that looks like an uncomfortable position. That works?
No, I'm fine. Yeah.
Okay.
I appreciate you.
All right. Let's get on the record. This is 23 SC 191-995. It's State versus Ms. Parks. Ms. Parks is here represented by her lawyer, Ms. Green. Good morning, Ms. Parks.
Good morning.
Good morning, Ms. Green.
Good morning.
And the state is represented by Mr. Jordan. Ms. Parks, I know we had set this down for a plea on a different date and we had to reschedule. And I apologize for that because I know preparing for this mentally and emotionally is not easy. And so you were gearing up and then almost at the last minute, we had to move it. I apologize for that. It was an immovable thing that was happening, a trial that went much longer than we expected. So I apologize for that false getting ready for this difficult time and then having to do it a second time. That was not purposeful on my part, okay?
I understand.
Good, thank you. In a moment, Mr. Jordan is going to put you under oath. Once you're under oath, you'll need to answer all his questions truthfully and completely. If at any point during our conversation, because I'll be having a few questions as well, you have any questions or you just need to talk to Ms. Green anyway, let me know. I'm happy to hear the question. It may be a question for Ms. Green, but I'll need you to speak up if you're confused by something or you just need to have a minute with Ms. Green. Will you do that?
Yes, sir.
Okay. And I guess if you all are going to be standing, you're welcome to remain seated, but if you want to be standing, you might as well come up to the podium and we'll just do that from there. And if you don't mind adjusting that screen. Deputy Gordon will do it. We had it moved because we had a pro se defendant. Great. Thank you, Deputy Gordon. All right, Mr. Jordan, when you're ready.
Thank you, Your Honor. Ms. Parks, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
China Capria Parks.
Thank you. And at this time, are you taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you, and what is the highest level of education that you've completed?
I am 30 years old in technical college. Technical college.
Okay.
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the following offenses? Count 1 being murder in the second degree. Your Honor, the state is reducing that charge to involuntary manslaughter, which is OCGA 16-5-3. Count 2, 3, and 4, Your Honor, the state is moving to dismiss those counts. Ms. Parks, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Ms. Green, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with her services?
Yes, sir.
Ms. Green, are you satisfied that your client has a full understanding of this proceeding?
Yes.
And Ms. Green, have you reviewed the indictment in this case with your client?
Yes,
Do you waive formal reading of that indictment?
I do.
Ms. Parks, do you recall originally having been arrested in connection with this case?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Green, do you know of any outstanding warrants that are related to these charges?
No, I do not.
Ms. Parks, do you understand that you are entering a guilty plea to 1 count of involuntary manslaughter?
Yes, sir.
Do you understand that the minimum for that offense is 1 year and the maximum is 10 years?
Yes, sir.
Do you understand, and my apologies, Ms. Parks, did your attorney previously advise you of the minimum and maximum sentence range for that charge?
Yes, sir.
Ms. Parks, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, the state's recommendation is 10 to serve 4, with the balance being probated. The special conditions of probation being that Ms. Parks be subject to a substance abuse evaluation and follow recommended treatment, and also that she have no drugs or alcohol while on probation. And as previously stated, the state is moving to dismiss the remaining counts on this indictment. Ms. Parks, was that the negotiated recommendation that was communicated to you?
Yes, sir.
Do you understand that the court does not have to accept that recommendation and can sentence you to the maximum on this charge?
Yes, sir.
Ms. Parks, do you understand that if you are placed on probation of any kind as part of the court sentence, you cannot violate any criminal laws of any governmental unit or any of the special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in the other jurisdictions, including the federal courts?
Yes, sir.
Ms. Parks, are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, sir.
Ms. Parks, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, sir.
Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, sir.
Have you ever been sentenced for any crime, whether that be a felony or misdemeanor, under the First Offender Act?
No, sir.
And has your lawyer explained the First Offender Act to you?
Somewhat.
I'll talk to you about it when you and I are having our part of the conversation.
Okay.
But it's not, you understand the basics, that it means it's not a conviction. And if you successfully complete your sentence, it's nothing that was ever on your criminal history. You understand that?
Okay, I
Okay,
get
we'll
it.
talk about it more in a little bit.
Okay.
Ms. Parks, do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for this charge in the indictment that you're entering a plea to?
Yes, sir.
Ms. Parks, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Ms. Parks, do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? And at the end of the list, if you can tell me in the affirmative or the negative that you understand that by pleading guilty, you were giving up these rights. Do you understand that you're giving up the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you, or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Ms. Parks, how do you plead to one count of involuntary manslaughter and indictment number 23 SC 191995?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the sole remaining charge against you?
Yes, sir.
Ms. Parks, do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that since this is a felony charge, that you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, for a factual basis, on February 4th of 2021, officers from the South Fulton Police Department responded to the intersection of Flat Shoals Road and Gulliford Lane, which is within the confines of Fulton County, about a vehicle accident call with serious injuries. Your Honor, the responding officers, when they reached the scene, I believe that Ms. Parks had been ejected from her vehicle, her child had been ejected from the vehicle, and the driver of the other vehicle, Mr. Hardy, Hardy, had also sustained severe injuries. All 3 of those individuals were transported to different hospitals. Ms. Lyric Hartsfield, the decedent child in this case, was transported to Eggleston Hospital. She was declared deceased the next day on February 5th. The manner of death was severe head trauma and blunt force injuries that were sustained from the car accident. Your Honor, the South Fulton Police Department, along with Georgia State Patrol, then conducted an investigation. The Georgia State Patrol did get the crash data report from both of the vehicles. The crash data report determined that Ms. Parks' vehicle was traveling at 72 miles per hour in a 45 mile per hour zone. Mr. Hardy's vehicle was traveling 47 in a 45 mile per hour zone. The crash data report determined that Ms. Parks' vehicle veered into the lane that Mr. Hardy was traveling at, and it basically caused a head-on collision. That is what caused Ms. Parks to be ejected from the vehicle, and her child, the victim decedent in this case. Your Honor, the officers did speak with both Ms. Parks and Mr. Hardy. Both Ms. Parks and Mr. Hardy did admit to consuming alcohol prior to driving on that particular day. The state was able to get medical records from Mr. Hardy's stay at the hospital and Ms. Parks' stay at the hospital. Mr. Hardy was over the limit. I believe he was close to 2 times the legal limit, and Ms. Parks was well over 3 times the legal limit. The state, this was using ethanol serum levels. The state did intend on calling Christopher Tilson from the Georgia Bureau of Investigation to be able to testify as to the serum levels being converted to the blood alcohol content, which is how the state was able to determine their amount of alcohol level at the time of the accident. Your Honor, in determining a fair recommendation for this case, Your Honor, we did use the fact that Ms. Parks has no prior criminal history, the fact that both drivers were intoxicated at this particular accident, and also that Ms. Parks has paid the ultimate price by losing her child in this situation. We do believe that this resolution, which allows Ms. Parks to use her first offender to have a chance to complete this sentence and not have it on a record, was the most fair and reasonable recommendation that we could present before Your Honor. Nothing further from the state at this time.
Few questions.
Yeah.
One, what did the evidence show about how Lyric was secured in the car? I don't know how old Lyric was, so we may not even be talking about car seats, but if Lyric were 3, what do we know about car seats, no car seats?
The South Fulton Police Department did at that time cite Ms. Parks for not having a booster seat in the car. The crash data report shows that the child was buckled, but that there was no booster seat in the car, and they only determined this from the debris that was on the road because all the contents of the vehicle were essentially out on the street. That's how severe the accident was.
And was Ms. Parks wearing a seatbelt?
Your Honor, I don't believe Ms. Parks was wearing a seatbelt. That's correct.
So Lyric was, but perhaps without a booster seat, it didn't do a whole lot because Lyric was ejected as well.
Correct, Your Honor.
Okay. Has your office had any contact with the father of the child?
We have not, Your Honor.
I don't know if you and Ms. Green have negotiated when Ms. Parks is going into custody.
Your Honor, we did in previous negotiations, we would ask the court still at this time for a turn-in date, and as long as the court would possibly allow in this situation.
Okay, so you're not opposed to a turn-in date other than right now?
Correct, Your Honor.
Okay, thank you. I don't see anyone on from pretrial services, so I'm going to take you at your word that Ms. Parks, other than this, has no criminal history. All right, Ms. Green.
Yes, Your Honor. Thank you, Lady Jordan. Yes, Your Honor, we are in agreement with pretty much all of the terms the state has presented and negotiated with us on. I believe that the only issue of contention or point of contention would be the actual length of time that she would have to serve in custody. And perhaps if the court would allow for there to be a consideration for alternative means of custody that would not require for her to actually, be incarcerated in the traditional sense. And so we would like to now offer testimony from, I believe first our pastor, Pastor Reginald Griffin, who would like to speak on Ms. Parks' behalf.
All right. Pastor Griffin, if you want to come up. And the way we'll do it, there's a microphone right there. You're welcome to stand or sit, whatever works for you. Is the prosecutor camera on?
Yes.
Okay, let me add that to the mix so Ms. Rivers can see you. Sir, thank you for being here. If you could state your name and spell it for the court reporter.
My name is Reginald Griffin, REGINALDGRIFFIN. All right. I thank you for this time, Your Honor, and I thank the courts for allowing me the opportunity to speak on behalf of someone that I love dearly. She's my daughter in the gospel, and when she first came to our ministry, she came in as one that was broken, one that was very hurt, and explained to me what had happened. She had accepted responsibility, much guilt, and we did our very best through Christ Jesus to help heal her. I know that when sometimes people make mistakes in life, that they are life everlasting on this side. And this is her case. It's that feeling responsible for the death of her child and feeling like she has now caused havoc in some way in the life of her smaller child that's living, Lizzie. And we are supportive of her. But I want to say this. I want to appeal to you as the one that has to make the final decision. I want you and the court to put yourself in her place. Someone that have made a mistake and have to live with it for the rest of their life because they have caused the death of their child in some kind of way, or in this case, through an accident. But as much as they have did this, you love them because they're your children. And I'm saying on behalf of her, I'm asking the court to let mercy come before judgment. When I look at you, I don't look at you as a man just sitting there. But I know what the scripture says, that we should honor those that have authority over us, for they watch for our soul. I also know the rules are not a terror to those that do good, but to them that do evil. We didn't come to resist or reject anything that you have to say. But we ask you, as the one that has been blessed by God, to be a judge of situations concerning his people. I know she'd never come around me smelling like alcohol, smelling like smoke. I've seen her life literally change. And I told her that now it's time to walk by faith. And so I say to the courts, I say to, the attorneys, we know that you can't break the law, but we know that the people that stand behind the law can do the very best they can to understand that this lady gonna suffer if you let her walk out the door today, or if you put her in bonds. She's gonna suffer for the rest of her life. And I'm saying to you, if it was your child, if it was your brother or sister, if it was you, maybe you say, well, I wouldn't have made those mistakes. I can't even honestly say that myself, because there was a time when I was young and I drank and I smoked and I whoremonger and I did all those evil things. But the mercy of God brought me out. And I stood before the courts before myself. And I experienced mercy before judgment came. And that's all we're asking today. And I humbly even put this request before the court. And thank you for this opportunity. Appreciate you.
Pastor Griffin, thank you for your comments, and thank you in particular for your support of Ms. Parks. She came to you in a time of need, and it sounds like you and your congregation were there for her. And if you weren't, who knows what might have happened. It was a very, very dark time for her. Not that things are a whole lot better now, but if you and others help lift her up and help strengthen her faith, that's an invaluable gift. So thank you for that.
Thank you.
Thank you.
Thank you, Pastor Griffin. At this time, we would ask for a family friend and also church family member, Miss Sheila Bass. Come forward.
Ms. Bass, good morning.
Good morning.
If you could spell your name for the court reporter, please.
SHEILABASS.
Tell me how you're connected to Ms. Parks and then share what you want to share.
Okay. We do what we call evangelistic work. I mean, we go out and we talk to people about Jesus. And that's how I was able to meet Miss China. And through that, we have had a good fellowship together since she's come a part of our ministry. I'm over our women's department, and China has been very active when it comes to her. She would help read scriptures, anything that she could do to participate and enhance the service, which brought healing to her. I've seen her interact with her own daughter. I must say I have a grandson that has autism, and we was all together one day and he became aggressive, not intentionally, but that happens. And she was teaching her, no, we don't do that. We don't do that. And I explained to her, I said, I apologize. He has autism, but she was very, very protective of her child. And I understand that, saying, you know, we don't act that way. I've seen her interact with her daughter. She loves her very much. I didn't have the opportunity to know Lyric, but I know that Lizzie, you know, I'm asking, you know, that she have that opportunity to have her mother in her life to raise her, but nobody loves her like her mother. And China is a very good person, as Bishop has said, you know, coming in and saying this was able to open up to us and tell us what actually happened in her life. Through that, the Lord Jesus Christ has brought healing in her life and to her family. And I thank the Lord for mercy today. And I heard the things that have been spoken already. And I know that mercy will continue to avail in her life. And thank you for allowing me to speak.
Thank you, Ms. Bass.
Thank you, Ms. Bass.
Hello.
Hold on one second. I don't know who's talking there. All right. Did you have someone who was going to be online? Because there's a Samsung phone where someone just started talking.
That's my mom.
That's your mom? Okay.
Yes.
Is that someone?
I'm sorry. I sincerely apologize. I didn't know how to ask to speak on her behalf. So I sincerely apologize for disrupting the court, but I just wanted to speak, if it's okay.
So it is okay, but I'm going to ask you to sit tight for a second. We'll go in the order you want, but let's include mom.
Okay.
All right.
All right. We'll have Pastor Marie Green to speak.
There's a lot of pastors today.
Yes. And then following, if China's mother would be permitted to speak.
Sure. Good morning, Pastor Green.
Good morning, sir.
If you'd spell your name and then share with me what you want to share.
Thank you very much. My name is Rose Marie Green, ROSE, Marie. My last name is Green, Greene. Yes. Yes. And I do appreciate the opportunity to speak this morning. And I think that I speak from a unique position. I've not known China a long time, actually since the accident, but I have been in her shoes. I have, not me personally, but I had a similar incident in our family where my eldest grandson was killed in an automobile accident, and it involved another family member. And I can just tell you that our family came together as a village, as China's family has. And we hurt, of course we hurt, and we cried and we grieved, but it would have been exponentially worse if the other family member had been, had received only judgment and not mercy. And so I am a mother of 7, and I know the pain. In the course of raising 7 children, there are certainly times when I've made mistakes. Thankfully, there were none that resulted in a fatality, but I could only thank God for his mercy. And so I asked to speak this morning just to join with her village and those who support her in asking you to please have mercy. She has the most beautiful little daughter now who is looking to her mom for a life. Even though there are others who will assist her, I'm sure there's nothing like mom. And in addition to those who she's known longer than myself, I will also say that I'll be there for her in any kind of counseling capacity, praying capacity, and whatever capacity. And so I thank you, sir.
Thank you, Pastor Green. Ms. Parks is blessed to have several pastors who are here in support of her, and more importantly, will be there to support her as she moves forward.
Yes.
Thank you for being here.
Thank you, Pastor Green.
All right. What's your mother's last name?
Miss Parks.
Ms. Parks, if you can turn your camera on, we need to be able to see you as well. There you are. I'm going to add you to the screen. All right. If you could, I know how to spell your last name, but if you could state and spell your first name, and then I'm happy to hear from you.
Absolutely. First name is Tally, Tally, and last name is Parks.
Okay.
Okay. This is the most awkward position to be in. Jesus. I'm just asking for mercy for my daughter. Give me 1 second. I won't be long.
Take your time. These are not experiences that we prepare ourselves for.
Judge, I know there's a job that you have to do. But I can promise you, as China's mom, this is not my daughter. This is an unfortunate situation. That has tried to claim the lives of my daughter. It unfortunately took my granddaughter, but this is not my daughter. She made a mistake. She has owned it, and she has made great efforts in changing. There's no justice here because Me losing my daughter to a system is no justice. Me losing my grandbaby to an unfortunate situation, no justice. I know respectfully that she has to pay a form of price in the in the reality realm, but she pays for it every day, every day, every day. Um, she's a great mom. She's a great mom. She's a great mom too. I don't speak about lyric in past tense. So I speak about her in present tense. She's a great mom to Lyric, and she's a great mom to Lizzie. We we didn't receive manuals. We're human. We make mistakes, but it's when we make mistakes and we learn from them that really matters. And I can honestly say that she has learned from her mistake. Literally, I'm still grieving for my grandbaby. She gives me inspiration that it's gonna be okay. It's hard, but it's gonna be okay. It's gonna be okay. To be absent from the body is to be present with the Lord, and we're the ones that need to worry. Lyric is okay. I just don't feel that. Oh Lord, Lord, Jesus Christ, Lord. Oh Lord, 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 Jesus. I don't know. I like I said, Jesus, Lord. Oh, Jesus, Lord, Jesus, Jesus, Jesus. Judge, Your Honor, I'm just asking for mercy, Lord. I'm just asking for mercy. Mercy on your behalf. She's doing good. She's been doing great. She has not been drinking. She has not been smoking. She has not, Lord. She has not. And I am proud of her. I am proud of her. You know, it takes a strong individual to go cold turkey without treatment, without help. And I think her help was losing her daughter. Realizing that it just wasn't worth that. It wasn't. Lyric is the best thing that happened to us. She was she's my first grandbaby. I was there to see her come out, the whole nine. And I'm telling you, China, those babies cling to her. They cling to her like they cling to me, my babies. I was just telling her yesterday, I just look how Lizzie just clings to her. How it's like Lizzie love everybody else, but it's like she want her mama. She won't let her mama go. So, I just know stripping her from her, I just don't want that to weigh on her as well, because she deserves her mom 100%. She was born into this world not knowing, but yet she's an innocent angel to her because she was an inspiration for China's change as well. Judge Your Honor, I just ask for mercy on my daughter. Our family has been through enough. We're still hurting every day, every minute, every day, every day. every day. It's not a day that Johnny and I don't sit on the phone and we talk about her and we reminisce. And I know it hurts my daughter, but my daughter has no idea that she's keeping me strong because that was her child. Her child. That's just she's my grandbaby, but that was her child. And how she could be so strong, I know it's nothing but the Lord. I know it's
Jesus.
nothing but God. I know it's nothing but God.
Jesus.
And as strong as my faith is in God, she's my inspiration. Because I don't know if I could ever go on with losing one of my children. Judge, Your Honor, I ask for mercy for my daughter.
All right. Thank you, Ms. Parks. I appreciate you dialing in, and it's fine that you appeared this way rather than in person. The important part was hearing your words in support of your daughter and helping me understand what the family's been through. I appreciate you participating.
Oh, everybody who showed up for my daughter, Lord God. I thank you, Lord God, because my strength, oh, Jesus, Lord, I wanted to be there, Lord God, but oh, Jesus, Lord God, this is heavy. This is heavy, Lord God. Oh, Jesus, this is heavy. Oh, God.
Okay, Ms. Parks, I'm gonna turn back to Ms. Green now, okay?
Yes, thank you.
All right.
Oh, Lord.
Thank you, Ms. Parks. Thank you so much for joining us and for your words. Your Honor, at this time, Ms. Parks would like to share her own words.
Sure. Ms. Parks?
I want to apologize first for my negligence. I just want to apologize for my negligence. I wish I can take everything back. You know, I'm standing here on faith, and I apologize.
I'm confident you think about it every day and you ask yourself, why not me? Why not me instead of Lyric?
Yes.
I'm confident you think about that. But it wasn't you, it was Lyric. And here we are. We need to work through the next steps.
Yes.
How old is Lizzie?
Yes.
How old is Lizzie?
2.
So you had Lizzie after you knew you had this case?
Yes.
Yes. Okay. And what is your plan for Lizzie if you are going to be away from her for a while?
I'm still getting things in perspective with that.
Is Lizzie's father active in her life?
Yes.
Is that an option?
It's discrepancies there.
Okay.
Yes.
So what's your plan?
I've been communicating with my mom, so I'm trying to get some things in perspective.
Is your mom locally situated?
Yes,
Okay. Do you have siblings?
I do.
Are they local?
Yes.
But I trust you've been coming up with a plan if the way this turns out that you need to be away from Lizzie for a while.
Yes.
Okay.
Oh, Jesus.
What's the answer to Lyric's father's perspective on what should happen? Do you know that?
Lyric's father is incarcerated. He's been incarcerated for some time. So
Was he incarcerated at the time Lyric died?
Yes.
And has been in custody ever since?
Yes, since she was born.
How old was she when this happened?
She had just turned 6. I was trying to.
She was not a little kid, but wasn't a teenager. Have you had any communication with Lyric's father since Lyric passed?
No.
Do you think he knows she's dead?
Yes.
Why do you think that?
Now, Now, us planning Lyric service, her homegoing, we were in communication, but from that moment, yeah, we haven't spoken.
Okay.
Yes, sir.
Was there anything else you wanted to say?
I'm just asking for mercy for Lyric and for Lizzie.
And what does mercy mean in your mind? Everyone has asked for that. And your lawyer has articulated one vision, which is some alternative form of incarceration. What does it mean to you?
I don't feel like me being incarcerated will help my daughter, my current daughter that's living now.
The daughter you had a year after this situation, knowing you had these charges.
Now, it was unexpected. I didn't plan on getting pregnant. Like, it was unplanned. I didn't just deliberately get pregnant. Yes, sir. Now, I do know that I violated the law. And so I do know that I have to pay a price for that. And so as far as mercy, I'm asking for an alternative and cost. Like, I understand I have to pay a price, but I'm just asking for an alternative way of paying the price. That's what I mean by mercy. My daughter needs me, and I know my firstborn needed me, and yes, sir. And I was negligent, and that's why I'm saying some type of alternative repercussion, because I did create something. I'm sorry.
You don't have to, you do need to apologize, but not to me. You should tell me what's on your heart.
Yes. I'm guilty, but I'm not guilty. And I understand that I have to pay for my consequences. And so I'm not asking to just not have to do anything, but I'm asking that you take my second daughter into consideration. That's all.
Okay.
Yes.
Mr. Jordan, what can you tell me about how Mr. Hardy is doing now and how seriously he was injured? We focus on Lyric, but there's someone else who could have died as a result of an accident that appears to have been Miss Parks's fault. I appreciate Mr. Hardy was also drunk, but it sounds like the mechanics of the accident were that he was maintaining his lane and Miss Parks veered into his lane, creating the head-on collision.
Your Honor, when the state spoke with Mr. Hardy prior to this case being placed on the trial calendar, he said that he had a few nagging injuries, but for the most part, he has recovered since this incident.
Okay. All right. Ms. Green, anything else?
No, Your Honor, I'll just join along with the others who have spoken. I've worked with China since day one on this. I've witnessed personally her growth. I watched her go through severe depression when the incident occurred. And really, I watched her climb her way to where she is right now. And it wasn't easy, you know. We spent hours on the phone and just trying to work and navigate our way through the legal aspect of the case. Will also join in along with her in the fact that her daughter is very attached to her now. And I know that that can't be the whole consideration, but as far as considering victims, I think that it's, of course, Lyric was definitely the main victim, but Ms. Parks is also a victim. And as you heard from her mother, she's a victim as well. And then also Lizzie would definitely be the, I think, most suffering victim for the course of the remaining of her life if, you know, in these growing stages, if her mother was removed from her presence for an extended period of time.
Ms. Parks, are you working now?
Yes, sir.
What do you do?
I'm a business owner. I started a business, a courier business. I pick up freight and I deliver freight to different locations. I do security from time to time. I was just doing security out in Douglas, Georgia, for the natural disaster that we just had with the hurricane. I'm active in my church and.
And you're a mom, which is a
Yes.
job too.
Oh, yeah, I never clock out.
Understood.
Yes, sir.
As a dad, I get that.
Yes, sir.
All right. First offender, Ms. Parks, is a benefit that you've earned by having no felony convictions. What it means if I sentence you as a first offender is that while you're under sentence, you're not a felon. And so as you continue to work and may choose to go back to school or whatever course you chart, when that question comes up, are you a felon? The answer is no, you're not. You are under sentence, but it will be as a first offender. And if you successfully complete the sentence, then you and your lawyer can take steps to have all that expunged and taken off your record. The risk of first offender is that if while you were on first offender sentence, you were to do something that violates the law, you'd come back in front of me and we'd have a hearing, but with a pretty low burden of proof. The state, if they demonstrated you did something different, something illegal, and what would be particularly problematic would be like getting a DUI or something like that. I could revoke your first offender status and resentence you as if you had just pled guilty again. And here I could sentence you up to the 10 years. That is the maximum for the involuntary manslaughter. And I tell you that not because I think that's going to happen. I don't think it will happen, but I need to make sure you understand the risk or the downside of first offender. It's not free. It's an opportunity for someone who says, there was this situation, that's not me, and it's not going to happen again. But happening again would be anything where you get in trouble. It could be a shoplifting, it could be a drug charge. It doesn't have to be this. If you get in trouble with the law again, you risk your first offender and could be resentenced up to the maximum. Do you understand that?
Yes, sir.
Understanding the benefit and the risk of first offender, do you want to be sentenced as a first offender?
Yes, sir.
Okay. I think that makes sense for you. This is an odd case in so many ways. It's not common where someone is killed as a result of another person's conduct. And we talk about first offender, but I think this is one of those rare circumstances where first offender makes sense. You will always carry with you the burden of what you did, but this need not define you forever. It's going to define you for a while longer. You're going to be under sentence for 10 years, whether you're in custody or not, but that's not forever. And there needs to come a point where that door closes and you move forward, again, carrying the grief and the burden, but you're done with the criminal justice system. So I think first offender makes sense. I find there's a factual basis for your plea and that your plea is knowing and voluntary. Knowing means you've understood all the things we discussed. Is that a fair statement?
Yes, sir.
And voluntary means that while you're not happy to be where you're standing there because you and Ms. Green have decided this is the right way forward for you. Is that true?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that while you're on probation, I don't think you're going to have any violations, but if you have a small violation, a technical violation, you and probation will figure out what the consequences are. But if it's more significant, any kind of violation of the law, that comes back to me. So this is no less difficult for me than it is for anyone else who's been talking about this. But I want people to stop calling this a mistake because it makes it seem like it was a minor thing.
Yeah.
This wasn't a mistake. A mistake is you meant to give Lyric her blue dress and you picked the red one out of the drawer because you weren't looking. It's a mistake, honey. I got you your red dress. Just wear the dress. It's not an unfortunate situation. People use that phrase as well. Your daughter died and it's on your shoulders. It's not on anyone else's. And mercy started with the prosecutor. Everyone should understand that. A hard-nosed prosecutor could have said, tell the jury your story. And the jury actually doesn't get to hear all the sympathetic stuff because it's not about character. It's literally about what happened that time. You were drunk and you killed your daughter. That's what the jury would hear. And I think they'd find you guilty of second-degree murder. And they wouldn't be right or wrong. They'd say that was the proof. And then we're talking about a very different sentence. So mercy has already started with the prosecution agreeing to reduce this to involuntary. But we're dealing with a tragedy. It's not a mistake. It's not an unfortunate situation. You made a series of decisions. It wasn't just, hey, I'm going to take a right turn and you guys accidentally went off a bridge. You put in your system what you put in your system. Put your little girl in the car and you drove and you drove. I'm not saying this to, I feel your pain and it's legitimate, but I want us to be serious about what happened and not whitewash it because a few years have gone by and you're a mom again. You were a mom and you took on the responsibility to keep your daughter alive and you didn't do that. We don't have to make our kids the next president of the United States or a football player or a teacher or a doctor or a lawyer. We do need to keep them healthy and alive. And you didn't do that. And there are consequences for that. Society expects that there will be consequences for that. Part of my role is to make sure that that happens. It's not a fun role. There are plenty of things that I do, adoptions and marriages and this and that, where everyone leaves the room happy. This isn't one of, you didn't come in this room happy and you shouldn't have, and you didn't. You're not going to leave the room happy either because Lyric is gone and there's nothing any of us can do to bring her back. But I think reasonable people expect that there would be consequences for getting as intoxicated as you were and putting Lyric in harm's way. Not calling someone to say, come pick her up, or we're just going to sleep in the car, or whatever. And I'm not putting, people have asked, your pastor asked me to put myself in your shoes, but I don't know what challenges you were facing. Clearly, you couldn't call dad to come pick her up because he was in prison. And so I'm confident that you faced a number of challenges that I'm discounting and not intentionally. I just don't know what you were struggling with. And people don't drink and drive with their kid in the car because they're happy with life. There were challenges you were facing. But none of that excuses what happened, and none of it brings Lyric back. I am reassured by the support you have here and the faith that you have begun to build, because if it's genuine, and I get the sense that it is, it will sustain you through the coming years. And what happened in February of 21 doesn't have to define you forever. Again, you won't ever forget it, but there will come a time when you're Lizzie's mom and you're a business owner and you're not, you killed your daughter. Right. But today we're here to talk about that and deal with the consequences of that. Ms. Parks, I believe that a reasonable sentence in your situation is a sentence of 8 years to serve 2 years with a balance on probation. You will need to go into custody and you will be away from Lizzie. This is a parolable offense and you have a spotless criminal history. I expect that you will be paroled. I don't control that. I'm never asked one way or the other. But you are going to be taking some time away as a consequence of the series of decisions you made on February 4th that led to your daughter's death and could well have led to Mr. Hardy's death. I don't want him to be forgotten in this equation, and could have led to your death. You don't wish that on anyone, and nothing about this was intentional. And that's why I believe the state started the mercy process. That's why I'm imposing a sentence a little less than what they recommended. I don't think that sentence was unreasonable. I think that it fits the gravity of this situation. Lyric didn't get to finish grade school. All the things that you've gone through in your head and that you won't get to do with her, but you will with Lizzie. You will get out, you will be back with Lizzie, and you will be with her for the rest of her life. At most, she'll be 4 or a little past 4. You will have 5 and 6, and then you'll be in uncharted territory. You will have a daughter who is 7 years old, and you will hold her hand when she finishes grade school, and you'll be there with her first boyfriend or girlfriend or whatever she does. You don't get to do that with Lyric because of the choices you made on that day, and that's why there are these consequences. I am equally open to the notion of a turn-in date, but it needs to be relatively soon and not too far away, because life gets very complicated for someone who's facing a term of imprisonment. So I want to be sensitive to Ms. Parks's need to arrange for Lizzie, but I draw strength from the community that's present today to include her mother. And I know that Lizzie will be cared for and sheltered while Ms. Parks is away from her. But we do need to set a date, and you need to understand, Ms. Parks, that if you are not here on the date and time that we agree to right now, then the sentence that I sign is the sentence that Mr. Jordan recommended, which would be 10 to serve 4. So you will have doubled your portion of incarceration if you don't show up for court on the date when you need to turn yourself in. And when you come to turn yourself in, do not bring your daughter. You can have support with you, but you're going to come dressed as plainly as you can. Don't bring a bag, don't bring a phone or anything like that. And you come here, you'll come to court because we start the process here, and you'll turn yourself into the deputies in my courtroom. Okay. We have to talk about probation. I will impose a special condition of probation that when you do start probation, you submit to a drug and alcohol abuse evaluation. But that's just to make sure you are on stable footing with addiction. And if that expert determines that you need some form of support, counseling, treatment, groups, that will be part of your probation. And that's it. I will set a behavioral incentive date. Well, I can't do that because I don't know when it will start. But what I will do is encourage your lawyer, Ms. Green, to come back to me if you have had a few years of spotless probation. Let's talk about either making it unsupervised or maybe even just closing the case out early. I am sincere about wanting this to be something that doesn't define you externally forever. Internally, it's always there. You have a scar on your heart and on your soul because of what happened, and it doesn't go away. But the rest of the world doesn't have to see that. That's your personal private burden that you will carry everywhere. But there needs to come a time when you're Ms. Parks, the successful mother and business person, and not, oh, why do you have an ankle monitor on? Or something like that. That's not today. It's not for a few years, but I'm very open to having you achieve that sooner rather than later, after you've dealt with the consequences of what happened in February of 21. Okay. Do you have any questions about anything I've discussed?
Okay, so the sentence that you're sentencing me is I have to do 2 years.
Correct.
Okay.
But this is a parolable sentence.
Okay.
And so Ms. Green can talk to you about that. Parole is a mystery to me. I don't know how they do it other than there's some things that are non-parolable. And I also know that if you're going to prison for your 9th conviction, they're not really interested in paroling you. You are going to prison for your first and only time. And I suspect you will be a model inmate. And those are the two things, other than victims' families weighing in saying, no, don't give this person parole. You'll have the opposite, because your family is the victim's family, and they've already spoken eloquently and powerfully on your behalf. And so you've got all the things going for you that ought to make you a suitable candidate for parole. But don't take my words as a guarantee of anything. My control was, is it 4 years or 2 years or 10 years in prison? And I have weighed what I feel like I need to weigh, to include being a voice for society that has the right to be safe from someone 3 times the amount of alcohol in her blood driving on the streets. You could hit a little old lady walking on the side of the street, and there's someone's grandma, and never intentional, but still reckless. And that falls in your lap and not in anyone else's. So, yes, 2 years. I suspect it won't be all 2, but that's the most it would be. Now, I looked at your situation. You were only in jail for 4 days before you bonded out. Sometimes I'm able to say, oh, you get credit for time served, and you will. You get credit for those 4 days, but that doesn't do much. If you had been in for a year on these charges, then you're halfway there. But it's 4 days.
I understand.
Did you have other questions?
So you said my turn-in date
should be soon.
Right. And so that's the last thing we need to talk about is when is that turn-in date? And I'm confident soon in your mind is different from mine. So we should discuss because you're going to leave today knowing when you need to come back. It's not going to be a surprise. There'll be a specific date and time when you need to be back here, and we should figure out when that's going to be.
Oh, Jesus.
But let me add this before you say, hey, I need a few months. We were going to do this a while ago and you needed to be ready. And in fact, your lawyer and Mr. Jordan and I had a discussion even longer ago about your need to get things lined up should you be going into custody. So I'm open to hearing things, but this is, you sort of had a dry run of getting ready of what am I going to tell the judge about a turn-in date when we had to postpone the hearing. So I'm pulling up my calendar here. Tell me what you have in mind.
No, can we do December?
So I'm thinking November. I was going to suggest November 1. That's a month from now. If you can help me understand why that's too soon, other than the obvious, I don't want to leave my daughter. I get that. And so really what you should ask for is never. I never want to turn myself in. But you've already told me that. Your mother has, and members of your faith community have. So I've heard that. But you need to help me understand what you need to do beyond November 1, which is a month from today, 4 weeks from today, why that date wouldn't work.
I need to get some things in perspective with my daughters. Who's my daughter going to be in custody with? So I think a month might be too soon.
This is not something you've already been working on. Again, we were going to do this.
Yeah, it's just like I said, it's a discrepancy as far as with the trust with her father and his mother. So I'm trying to be fair when it comes to Lizzie.
Okay.
Yes, sir.
So what's your suggestion?
I have to get some things together with my mom, with my daughter, so that way she's able to be in my mom care and able to see her dad as well. But I'm dealing with difficult people.
Meaning her father?
Yes.
Okay. How often does Lizzie see her father right now?
Every other day. She's with me. Yeah, every other day. But
meaning he just visits with her, or she spends Monday night with you, Tuesday night with dad, Wednesday night with you, Thursday night with dad?
So me and her dad, we're together. It's a family dynamic. Yes.
Okay.
But
like if you invited me over for dinner tonight, it would be you and her father, meaning Lizzie's father, and Lizzie, all in one household.
Not exactly.
Oh.
Yeah.
Okay. It is complicated.
Yes. We've been trying to find somewhere to stay, so we've been staying with family.
Okay.
And so
you have to spread apart.
Yes. So some days she's with me most of the time, but when her dad wants to see her, I allow her to spend time with her dad.
Sure.
So he's not stable. And so that's
the
discrepancy. It's on and off, it's not consistent. So that's why I'm leaning more so towards my mom, because she has stability.
Where do you stay right now?
Stockbridge.
But with what relative are you staying?
My mom.
Okay. That's where your mom is?
Yes.
Okay. All right. So your suggestion is when?
December.
Tell you what, we'll do November 15th. So that's halfway through November. I'm meeting you halfway. I think November 1, that's still plenty of time. I just worry the longer you put this off, that's more time you and Lizzie are, I get it. It's gonna get harder and harder to pull that Band-Aid off that you have to do what you have to do. And so I'm trying to strike a healthy balance between, Monday, that wouldn't be realistic, versus it certainly needs to be before the holidays. That would be a bad decision, I believe, to say, let me have the holidays with family. All right, November 15th, 9 a.m., this courtroom. This courtroom may be renovated, so it may be we tell Ms. Green, actually, it's courtroom X, but this building, 9 a.m. You'll need to be here in the format I described. Again, if you want to have one or two people showing up with you, that's fine. Do not bring your daughter, and don't bring anything then the clothes you're wearing. Okay? If something comes up and November 15th isn't going to work because of a medical emergency for you, let Ms. Green know and she'll know how to get me paperwork, et cetera. But it's not, oh, there's this or that. It's not easy. It's complicated. It's not going to get easier. And so I'm nervous by it being that far out, but I am respectful of your parental considerations.
Yes, sir.
So November 15th, 9 a.m. here in 8D. And Ms. Green, you're welcome to, you're not required to be here. That's a lawyer-client situation because there's nothing legal that's going to happen. So just work with Ms. Parks as to whether you're going to be someone who shows up with her. But you will need to run interference if she says, hey, it can't happen that day. And just a reminder, if it's 9:30 on Friday, November 15th, and I haven't seen you, then I sign a sentence of 10 years to serve 4 years. You'll have doubled your time away from Lizzie, and you're not going to be hard to find.
You don't got to worry about that.
I don't want to worry about it, but you're the one who's going to be wrestling with this. I just want to make sure you understand all the different outcomes depending on what you do. Okay?
I understand.
All right. Mr. Jordan, anything else in Ms. Parks's case?
Nothing further from the state, Your Honor.
Ms. Green, thank you for your work on behalf of Ms. Parks.
Yes, Your Honor, and I also would like to thank ADA Jordan for his working with us and also you, Your Honor, for your mercy that you did style this.
You drew a good prosecutor, and I appreciate his work on the case as well. Ms. Parks, I'll see you on the 15th, okay? Between now and then, be safe and be smart, okay?
Absolutely.
All right. Pastors, thank you for being here.
Thank you.
Thank you.
May we be excused? Yes.
Yes, you may.
Thank you.
So, Ms. Rivers and Officer Evans, we're back on at 1. So you guys enjoy a break between now and then, and I will see you all at 1 o'clock.
Okay.
Yes, Your Honor, enjoy.
Thanks. So I hope you have happier cases. Otherwise, I don't want you in my courtroom again, because I know if you walk in, it's bad news.
I'm trying to stay far away from these kind of cases. This was a hard one.
Well, it was good for you to be there for her.
Yes, thank you.
Thank you, Ms. Green.
Thank you so much.
Have a good one, Your Honor. Have a good one.
You too.
Oh, shit. Sinclair Burns.
Probably two.
All right. Good afternoon, everyone. We've got a plea and arraignment calendar that we're going to call before we turn to the sentencing in Parks and Phillips. Position 1 is Dontario Alexander.
Your Honor, I think he's in custody in Fayetteville County, and he was not brought over because of the storm, I believe.
Okay.
Someone told me that.
Here comes the guy with the paperwork. Dontario Alexander. In Fayette County, not brought over because of the storm? How'd I know that? Okay. So we'll need to reset that. Have you had any contact with him?
His girlfriend has been emailing me, but not him directly.
All right. And so you have Mr. Alexander. It looks like he's got a co-defendant, and that'll be someone else. But
yes, that's the conflict office.
all right. So Ms. Rios has that. Reset. So it lists that he has a warrant, but that's why he's in Fayette County. I guess we'll work through that when Mr. Alexander gets here. All right. How about Sental Burse?
Yes, Your Honor.
Yes, Judge, that's my case.
Okay, Mr. Burse, can you turn your camera on, please?
Yes, sir. 1 second.
Where'd you go? There you are. All right. Hello, Ms. Gibson. How are you?
I'm good, Judge. How are you?
All right. And we've got Mr. Burse. This is, I guess, plea and arraignment. This case was in non-complex and got transferred here. Ms. Gibson, did you have it when it was in non-complex?
I did, Judge.
Okay. So was Mr. Burse already arraigned, or did he waive arraignment? I know sometimes that step doesn't necessarily happen in non-complex.
We waived formal arraignment and entered a plea of not guilty.
Okay, let me see if that's in the books. If it's not, then I'll just have you, do we have a form we use so that it's clear in the docket? Nope, the waiver is in. Fantastic. So your counsel record, did you already get discovery from Mr. Malkin, or will Ms. Nix be assuming that responsibility?
I don't think I did receive any discovery. I know there's a certificate of discovery. Let me double check.
Okay. What that says is that you got, evidence.com link with GCIC warrant, drug lab, police report. So you should have received a fair amount.
I did get those things, Judge. It appears that I have most, if not all, of what's listed in that certificate of discovery.
Okay. Let me check one more thing with Mr. Burse. Okay, your bond conditions are pretty basic, so I think we're all set. Mr. Burse, do you have any questions?
No, sir, not so far. No.
Okay, well, does Ms. Gibson have a way to contact you?
Yes,
I do, Judge.
Yes, we've been communicating. She does stay in close contact with me. She be keeping me updated on the case and letting me know everything that's been going on.
Okay, well, good. Then Ms. Gibson will enter a scheduling order that will have a deadline for the state to provide discovery. I think they've already done that, a deadline for you to file motions, and that'll ensure that Mr. Burse's case keeps moving. Hopefully, Mr. Alexander can catch up. We'll get him from Fayette County in here soon and do the same thing.
Okay, Judge.
Check one more thing. Just want to understand why the case is here. Okay, so Mr. Alexander is a repeat offender and Mr. Burse just gets to follow along. Okay. All right. I think we've got what we need. Anything else, Ms. Nix, on the Burse case? Anything else, Ms. Gibson?
No, Judge, thank you so much. May we be excused?
You both may. Have a good weekend.
Thank you,
you
also.
too.
All right. Bye. Keandre King. He was released from custody over a month ago or about a month ago and was supposed to be here today. Have you had any luck contacting him?
There's no good number in the file.
Okay. I think this will be Ms. Clark's case going forward. I don't see her here or on the call. Ms. Nix, that means I'll defer to you. Bench warrant for Mr. King?
Yes, sir. We'll move for bench warrant.
All right. Ms. Rios, if you and he do connect, just let us know and we'll see what we need to do. I'm told Mr. Jordan will be handling Mr. King's case should it start to get traction.
Okay.
Okay. Position 4 is Demetrius Jefferson.
His presence was waived.
Okay. You did a waiver?
Yes.
All right. Jeffrey Villarreal.
He was sent to non-complex. He was never supposed to be indicted to complex.
Wow, we rarely get to do that. Excellent. Okay. Marquet Walker. Hey, Mr. Walker, where's your lawyer?
I'm his new lawyer.
Oh, you're the new lawyer.
I filed an entry because
Mr. Flugum withdrew. Oh, I think I remember this situation where he filed an entry and withdrawal on the same day. I don't know what's going on there. But, so Ms. Rios, you represent Mr. Walker.
Yes.
Okay.
If I can go talk to him, we could possibly resolve the case today. I just need to talk to him and then we could come back.
Great. So Mr. Walker, I'm gonna ask you to sit tight, and Ms. Rios may be talking, are you gonna be talking with Ms. Willingham?
Yes.
Who just walked in a very bright suit. So Mr. Walker, your lawyer is gonna talk with the prosecutor. We'll see, there may be a way to resolve it today. That's not required. You're gonna be able to leave either way. But if we can resolve it, then you never have to come back. Pardon?
Yeah, I want to resolve.
Okay, well, you gotta see, it could be that they're offering you 100 years to serve. My guess is that's not how you want to resolve it. So let Ms. Rios talk with Ms. Willingham. And we'll need to talk one more time, whether it's resolved or not, just to say waive arraignment, all that kind of stuff. Okay? All right. Joelle Lett. Would that be your case, Ms. Rios, or Ms. Wood?
Ms. Wood told me that he hired.
He hired, let's look. Oh, and there was a waiver, and there's an entry, Candace Hill. Okay, waive. Schedule order. So Ms. Nix, you will get discovery to Attorney Hill in the Lett case. Great. And then Mr. Holliday, we've got a waiver by Ms. Wood. So we'll get a scheduling order out. Almost done. Oh, that's Mr. Holliday. He has two cases. Huh. Why he has a bond? I'll have to look at that. Does Mr. Hiles have position 9? His name is listed. Ms. Wood's going to handle both those for Mr. Holliday.
Yes, sir. And he might also get position 8. He and I used to go and talk about it.
Okay.
That defendant, Mr. Holliday, is in custody on some new charges. So he.
Oh, he's so.
On these two, but does not have, is not out on bond.
Okay, so I definitely need to be thinking about bond then if he has even newer charges and he's got bond here. Okay. Do you have the new PI number?
I don't.
I can look it up. That's fine.
I had an immediate email yesterday, so I'm received it later.
Great.
I have it.
Okay.
Should be 24 PI 006740.
And how do you find that? Do you, you said something yesterday about some kind of name search. I want to learn how to do that.
So I'm on the jailing site.
You're on the jail side. Okay.
And I just clicked on his name and went to cases.
And then that gives you a PI number?
It gives me all the cases that he's been in jail for.
Okay.
As in, not as niggas.
Because if I go to his booking number, it gives, oh, there's the PI number. So I can also get at it through the booking number. Okay, great. 6740. All right, we will deal with bond in the other cases. And we'll see what happens here. All right, I think that does this calendar with the possible exception of Mr. Walker, who may resolve his case. So while they're talking, should we turn to Parks and Phillips? Mr. Menettis, are you ready?
Yes, Your Honor, I am.
Mr. Rowe?
I'm ready, Judge.
All right, come on up, please.
Your Honor, may I just step outside and make sure?
Sure. Did you need me or are you just coming out? Okay.
If you get a chance, can you sign the plan? That's a citizen.
Okay, I'm sure it's something you sent me. I'm gonna try to sign all that stuff. Ms. Rivers, are you ready?
Yes, I am.
Great. All right, let's get on the record then, please. In 21 SC 180098, State versus Parks and Phillips. We have Mr. Parks here with his lawyer, Mr. Rowe. We have Mr. Phillips here with his lawyer, Mr. Menettis. Mr. Griner is here for the state. We are having the sentencing hearing in this case. Mr. Parks and Mr. Phillips were both found guilty of all counts against them in the indictment, which is counts 1 through 6, by a jury. And we had to defer sentencing because 1, the day was packed, and 2, Mr. Menettis asked for some additional time to be prepared to present some mitigation evidence at sentencing. So what we're going to do first is hear from Mr. Griner on behalf of the state. And if he has any victim impact information, I certainly want to receive that from him as part of his presentation.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, I believe, first of all, that when we examine the indictment, that counts 2 and 3 should be vacated. Count 4 should merge with count 1. And that leaves us with count 5 as a viable count, and also count 6. So.
And 1.
Yes, 1.
Okay.
Yes, to begin with 1. Yes, Your Honor. So, Your Honor, what I'd like to do is.
What's the range for criminal damage to property in the first degree?
It's a 1 to 10 year offense.
Okay.
Your Honor, I've got a copy of the juvenile legal history for both of these defendants, if I could approach and hand the court a copy.
Are those things you shared with Mr. Menettis and Mr. Rowe?
Yes, Your Honor, I've provided each with their own copy.
Okay, thank you. I'll take it. Thank you.
Your Honor, in addition to those 2 documents, there is a third document I've handed Mr. Menettis. It has some notes pertaining to the juvenile court. I don't know who the author of those notes are. May not be relevant to this proceeding, but so as the court can see, I'll start with Mr. Parks. As the court can see, Mr. Parks, although he may not have much of an adult history, he does have several delinquent adjudications as a juvenile. Back in 2017, he was adjudicated delinquent for burglary and cruelty to animal. He had a separate burglary adjudication in 2017, a third burglary adjudication in 2017. And he also in 2018 had an obstruction charge, a possession of criminal tools, and then another charge. And so I'll just kind of set that out to the side, and I'll come back and address Mr. Parks again in a moment. As far as Mr. Phillips goes, he has criminal attempt, false imprisonment, adjudication of guilty back in 2018. He has several delinquency adjudications in 2018. Possession of looks like a prohibited substance in 2018. It looks like at least a third delinquent adjudication in 2018. And then he's got an obstruction, a loitering and prowling in 2019, and then a separate obstruction in 2019. Since Mr. Phillips has been incarcerated, however, there was a fight at the jail that occurred on March 3rd of 2023. That fight involved Mr. Phillips and 6 other inmates, for a total of 7 who attacked 2 inmates. The 2 inmates were beaten, and they also were stabbed with more than one makeshift knife at the jail. And so there are, I presume that there are charges that are coming arising out of that incident, which would include aggravated assault and, possession of a knife and unauthorized possession of a weapon by an inmate and so forth. So those are sort of the background histories of these 2 defendants. But of course, what makes this case really stand out in stark relief to most murder cases that we have. This is, as the court is aware, this is not like a drug deal where people are getting together with unclean hands, or a domestic violence relationship stemming from a volatile relationship. This is a case which is not entirely unlike some of the cases that we read about in national news on occasion, where we have a total of 3 people with guns shooting in an environment where they may not realistically expect anyone to defend themselves or to be able to defend themselves. They targeted a house with 9 people in it. Their stray bullets struck 2 additional residences, as the court knows. This entire neighborhood was victimized on that day by these 2 defendants' actions, of course. And, it's only luck that separates this case from some of the others with multiple shooting victims. But what we have here is a complete lack of regard for life. When these 2 and their friend opened fire and the deceased victim collapsed at the very beginning of their opening fire, these 2 defendants actually looked at the body. They were only a few feet away. They looked at the body. For Mr. Parks, it was a next door neighbor. For Mr. Phillips, it was someone that he knew through a different series of relationships. They looked at the body, and then they continued firing at their house, their intended target. And then they ran up the street, and this is entertainment on this day. This was fun. They were skipping. They were enjoying this, seemingly. This was a fun entertainment event for them as they're pouring 31 bullets around the neighborhood. The absolute disregard for life is evident, not only in their initial shooting at a house where they know that there are people in. They just walked down past this house and seen people moving furniture in and out, children in the yard. It's a teenager there on the corner playing basketball, other neighbors that are visible on the videos. that we've seen out in their yards. They knew all of this. Then they saw the next door neighbor get shot, and then they continued going up and shooting. This is a complete lack of disregard, or a complete lack of regard for life. They didn't do anything at all to help the deceased victim. Maybe if they had stuck around and tried to supply some kind of first aid, or been the first to make a 911 call, or have done something to get some kind of professional assistance there earlier on, maybe there could have been something done. We'll never know. But they just displayed a complete lack of regard for life. They also have shown no remorse. There was no remorse there in the hours and the days following this. No remorse here in the courtroom. I doubt there's going to be any remorse shown today. And if there is remorse, it's going to be over the verdict and not necessarily what happened back in September of 2021. And then we get into the false statements, the lying, all of these other things that have played themselves out, not only in the immunity hearing, but also at trial. And so, Your Honor, this is beyond just a tragedy. Everyone out there in the state's position, everyone out there in that neighborhood was a victim. It is a miracle that only one person was shot. There is very little difference between this case and some of these other cases that we unfortunately read about in the news. So the state's recommendation is going to be life without parole as to count 1, 10 years to serve consecutive to count 1 on count 5, and on count 6, 5 years to serve consecutive to counts 5 and count 1. And if this is the appropriate time, I'd like to call the deceased victim's mother, Melissa Arnold, forward to make a statement in court.
It's almost the right time. I have 2 questions. You're recommending the same sentence as to both Mr. Parks and Mr. Phillips?
Yes, Your Honor.
What is the state's understanding of where G is? And he may never have evolved past the first initial G, in which case you've got no idea. But that's not anything I could ask in front of the jury. And I'm curious what the state knows about the whereabouts of G.
We're investigating that, and I probably should not say much more.
Okay. That's all you need to say. I would very much like to hear from Mr. Arnold's mother.
Yes, Your Honor.
Good afternoon, ma'am.
Good afternoon.
If you could state and spell your name for the record so the court reporter can get that down, and then anything you want to say is fine. If you want to have the victim witness advocate speak for you, this is a difficult moment, but it's important if there's something you'd like me to hear that I hear it.
My name is Melissa Arnold, MELLISSA ARNOLD. And I just want them to know that I miss my son very dearly. And it's sad that it took my son to be killed for, the situation in the neighborhood. Somebody was going to be killed, and they have not shown any remorse for killing my son. And, it's just sad, that they're going to be in prison. And I do recommend, please give them some time, because they don't need to be on the streets. They have not shown any remorse to me, even being in this courtroom. They denied, it's like, we don't care. But Tobias had people who loved him. I loved him dearly. And for them to take him from me was very, very, it's just incomprehensible. You took another young man who was older than you guys. But I did get the chance to spend 31 years with him. God did bless me with that much time. But I didn't get any grandkids out of it.
So Ms. Arnold, I need you to talk to me and not to them, okay?
Oh, I'm
Your words
sorry.
can be for them, but
I'm sorry.
that's okay.
Yeah, I didn't get any grandkids out of it, and you know, it's just devastating, but you know, they do need to serve time for what they did.
Sure. Was that your only child?
No, I had 4 kids and Tobias was my oldest son. I have a 36-year-old daughter and Tobias was 31 and he would have been 33 this year. And I have a 31-year-old, he'd be 32 this year. And I have a 29-year-old. So I had 4 kids, but Tobias was my oldest.
Yeah.
Yeah,
Okay.
yeah.
Anything else you want to share?
No.
I appreciate you being here and I'm very sorry for what you've been through. And I'm sorry, and this is nothing to do with Mr. Griner, that it's taken so long for us to get to this point. That wasn't fair for Mr. Phillips or Mr. Parks, and it certainly wasn't fair for you and your family.
Yeah.
With COVID and other things, it was hard to move this case forward. Make you feel any better about it, but I just want to apologize on behalf of the court system that it took so long to get whatever closure was going to be. A jury could have said not guilty. There could have been a plea. The jury said guilty. I understand why they did. And that at least closes one chapter for you. It doesn't bring your son back or anything like that. But I appreciate you sticking with the case until we got to this point. Okay. Thank you.
Thank you.
Thank you. So, Your Honor, I believe that we're past the point of restoration, and the sentence just needs to protect society from these 2 predators. Thank you.
All right. Thank you, Mr. Griner. Mr. Rowe and Mr. Monetis, we can handle this in either order. Have the 2 of you discussed in which order you want to go?
No, Judge, we haven't. I don't mind going.
Okay, I'll just call around the room that way. So Mr. Monetis, I am ready to hear from you and anyone else you've got here on behalf of Mr. Phillips.
Yes, Your Honor, I'd just like to say a few things, and then Miss Frida Gates, Mr. Phillips's mother, wants to address the court.
Okay.
Your Honor, as far as that separate case, it's
The separate case?
the jail case that the.
Oh, got it.
That's from 2023, hasn't been prosecuted. I don't know anything about it. I just got some papers thrown in front of me. I don't think that's appropriate consideration for this court. So I'm going to move past that, but I did want to place that on record. Your Honor, I think the state bringing up a juvenile history is incredibly important. I don't find that aggravating at all. I find that incredibly mitigating. I started my career as a juvenile public defender. I did 1,000 cases and I maybe met like 1 or 2 bad kids. There's a reason they're not criminal allegations and that they're civil actions, because children in juvenile court are children in need of services. You can see that that's what Mr. Parks was. He was a child. He was a child in need of services. The court can see he even exhibited behavior, self-harming behaviors during court proceedings.
And that refers to juvenile court proceedings. That's not something that happened since I've been working with Mr. Phillips.
No, not that
Okay.
I know of, Your Honor.
Me neither.
It's just something that I know of and that's been noted here. And so, Your Honor, those allegations were 1, incredibly dissimilar. 2, show, again, a child in need of services surrounded maybe by institutions, whether it's family or socioeconomic things or school that weren't able to meet some of his challenges. And his mom's going to speak to mental health challenges, child trauma, severe child trauma that this court knows can lead to problems. And yeah, he was a child in need of services, and those services, as the court knows, just don't always work. It's not like a chemistry set or a pill you can take that just makes you okay, makes society okay. So he was a child in need of services. The services sadly did not work. And again, Your Honor, I think that should give us at least the possibility of parole. This court, by granting the possibility, is certainly not saying he's ever going to get out. It's saying that he'll have a life sentence. They will get more than some time, as Ms. Arnold rightly is asking for. Before trial, we are attempting to resolve this. The victim's family was okay with the possibility of parole, but Mr. Phillips, I believe, had a story to tell. And, there was some back and forth about G, as the court's concerned about trying to find G and maybe getting a resolution that way that we can never reach common ground about. And so, yes, Judge, we did go to trial. And, you know, I don't want to litigate the case again, but I do think that some things that the jury said in our Q&A afterwards were significant. They found Mr. Phillips to be the party, not the principal actor, the party to this unplanned tragic event. And when I asked them for my professional curiosity, what was it that made him a party? They said that he was somehow, that was the exact word, that he was just somehow encouraged or assisted what we can't see happening on video. They didn't believe that beyond a reasonable doubt that he had a gun. There was this whole revolver thing back and forth. He didn't lie about that. That's a failure on my part as an advocate. I should have had an investigator come show how there is the revolver that he mentioned, the judge that has that long base. You know, that's neither here nor there. They found him guilty. They're the fact finders. So I'm here acknowledging that's a fact, that he's a party, but for some vague, you know, puzzling to me, but vague assertion that he's just somehow a party, Your Honor. So I don't think it's fair to call him a predator. Even the jurors themselves said that they found that term distasteful and inaccurate. They specifically said that. So he's not a predator. He's not found to have been a predator. He's found to have been a vague party to an unplanned event and an 18-year-old former child in need of services that just didn't go the way we wish they would have. And Your Honor, I find it puzzling to say he's shown no remorse. He did show remorse on the stand. He talked about Mr. Arnold being like family to him. I'll just leave that there. You know, Your Honor saw for the court itself that there is remorse. And Your Honor also heard from the medical examiner that said, sadly, there is a shattered brainstem and that it would appear to a civilian person that he was dead. So not rendering aid is not a factor to me. There's other people on scene that called 911 immediately. And I don't think that speaks anything to Mr. Phillips, especially in this scenario where they don't know exactly what happened. It's not planned. Miss Nell corroborated Mr. Phillips's version of events, which also corroborated Miss Blakeney's unused recording that the court heard. And the jurors told me that they just didn't find Miss Nell credible and that she must have had some sort of implicit bias or was confused. And Your Honor, that's all to say that I don't want to hold Mr. Phillips, you know, accountable for not having remorse or for wanting to tell his side of the story of things and to tax him now for going to trial and give him something worse than what he would have gotten had he resolved it. Because I think it's understandable for him to want his story to be adjudicated by the jury, which it was. And now we're here facing that accountability. We're just asking for the possibility of parole. And so, Your Honor, I do want to call at this time Ms. Frida Gates. Ms. Gates.
Hello, Ms. Gates.
Good afternoon, Your Honor.
Can you spell your first name for the court reporter, please?
Freda, last name Gates.
What would you like to share with me?
I wrote this down to keep me on topic. I want to be as long as I need to be, but I don't want to be too long. So, Your Honor, I stand before you now as a mother pleading for her son. My heart breaks. Not only does my heart break for my son, but it breaks for the Parks and Arnold families as well. I know my son has made mistakes, but he is not defined by them. So I ask for your compassion as you consider the circumstances that brought us here today. DeMario has had his fair share of challenges, and as his mother, other than God, I have been his biggest advocate when he couldn't or didn't know how to advocate for himself. I have fought diligently and relentlessly with the school systems, through juvenile court, even through this process. I fight on behalf of my son because of his mental health challenges and the need for constant support. I left my job in 2018 after the passing of our family's matriarch. Demario was getting in a lot of trouble. And so in order for me to step up and support him like I needed to, I needed more time. So I left the pharmacy. I had a full-time 8-year position, and I was able to care for him. Later that year, I stepped out on faith and started my own business, Kitchen Ministries. I own a catering company. In the previous year, my ministry partner and I, we partnered with Ponce Church to do a homeless feeding for the community. That was the beginning of Walking a New Ink. It is a 501c3 that was officially formed in 2020, November 2020. Through this work, we serve our community. We give a number of resources to the Black and Brown community. As a director, I facilitate 6 events yearly, and this is where Demario would shine. He would enlist the help of his friends and our neighbors, and it was always a joy having them to help us because we knew what they could have been doing. So stepping up to help, it delighted our hearts. Because of my ties to the community and the work that we do, I'm always serving. So after any catered event, my boys and I, there was always food left. We would pack plates and pass them out to the people on Hamilton Road in our community, or we would go to underpass communities and just give food away because I was raised up that it's a sin to waste food. Demario's young life has been one traumatic event after another. From the 2017 murder of his cousin DeAndre Phillips at the hands of the Atlanta police, to the murder of his brother in 2020, Cortez Harris, not to mention the attack. I think he was locked up maybe 6-8 months, and we got a call that we needed to get over to the jail because he had been stabbed. Mario, he got stabbed 14 times, and the most severe stab wound punctured his lung. He spent a few days at Grady, but I was able to put my eyes on my boy. He's endured a lot in his 21 years. And while many may not understand, I know societal pressures have weighed heavily upon him and potentially clouded his judgment. I don't know. Can I address Ms. Arnold?
You can share words with her, but you and I are having the conversation. I promise she's listening, but what's
Okay,
not
so
okay
just
is to turn towards her and say,
okay,
yep.
okay,
But I promise you, she's listening.
okay. We love Tobias. We loved him. He was introduced to us as Fabo, and I was getting to know him.
Did you live in that neighborhood, the Notting Hill neighborhood, or you lived near there?
I lived in Notting Hill.
What was your address? Do you still live there? I don't need you to give the address if you still live there. I'm asking you a question.
Okay,
Do you still live in the Notting Hill neighborhood?
I do.
Okay. So you had a reason to know Tobias because he was in that neighborhood as well.
Well, I know Tobias because Demario's girlfriend, her family, he was living with them. And so they were about to have a baby. And so it's like 2 families are going to merge. So I was getting to know his girlfriend's family, and Tobias was always there.
Okay.
So we had holidays together. I was just looking through pictures from the gender reveal for my granddaughter, and I'm looking at videos. Tobias is there. We had birthday parties, their house, my house. We were always around each other. And I miss him. I wish I was home that day to let Mario in the house, because I don't know if this would have taken place. Maybe he would still be here. But since that day, I have carried this lady in my thoughts and in my prayers. I wanted to reach out to her as a mom, but I couldn't, because I didn't know how it would look to the court because of some other stuff that was going on. And I didn't know if she would receive me. But I'm so sorry. I'm sorry for your loss. I'm sorry for what happened to Tobias. So even though I couldn't reach out, I couldn't do anything, I just took it to God in prayer. That's what I know how to do. I just prayed about it. So, Your Honor, I just asked the court for mercy today, because I believe that my son has the capacity to change. I believe that he has the power to be redeemed. Like, he is not the sum of his mistakes.
And Your Honor, that's all she has to share for the court, unless the court has more questions.
No, and I'm sorry, I thought you had paused for a second. I wouldn't have left you hanging there. I want to thank you for being here for your son throughout. And it looks like you're playing an important role in caring for your granddaughter, and for sharing your feelings right now as well. It's good for me to hear everyone involved as a person. We talk about a case or a defendant, and your son is a defendant in a murder case, and he's been convicted of murder, but he's still a person, and he's your son. And it is important for me to get additional dimensions to him beyond what I saw on video your son was doing. That's obviously pretty problematic.
You know, this has been a long process, but we've shown up every time for him. Me, his dad, his daughter, his girlfriend. We want to support him. I brought some of my church members, pastors, family, because we need everyone to know that Mario, he's not a thrown away child. He's loved. He's got a community behind him, supporting him, pulling for him.
Good. Well, thank you for sharing that. Mr. Monetis, anything else on behalf of Mr. Phillips?
No, Your Honor, just in closing, I'd ask the court to consider all of that social history, the mental health challenges, the vast support network, the potential and the redeeming qualities of Mr. Phillips, the fact that he was convicted of being a party to an unplanned event, and of course that he shares the same comments and emotions that his mom does about Mr. Arnold. And that, Your Honor, that the court is not granting parole. It's just a possibility of parole in a very, very long time, when Mr. Phillips might be 50, 60 years old, and when professionals that are outside of our expertise will make that determination. And so we're not letting him out or being merciful in any sense, in my opinion. We're simply acknowledging a possibility for other experts to do their job far off in the future, and they very well not give him parole, but I'm just asking Your Honor for the possibility, and Mr. Phillips does want to briefly address the court.
Okay. Mr. Phillips, you can do that right there. Why don't you share with me what you'd like to? And I want to be clear, you don't have to say anything at all. Mr. Monetis said you wanted to, And you have a right to, we call it allocute. It means say what you want to say about the situation you're in, but you're not obliged to.
I'm not no predator and I'm not no murderer.
Okay. Thank you, Mr. Phillips. Mr. Rowe.
Thank you, Judge. Judge, I do have one witness, but I would like to make an argument first before
Please.
I call my. Judge, just to echo what my colleague said regarding the juvenile system and the juvenile history, but I do want to read a statute, Judge, just for the court's consideration, and that's 16 it's 15 OCGA 15-11-703. It says except as provided in subsection D of code section 246609, so that deals with impeachment and evidence and witnesses testifying. The disposition of a child and evidence adduced in a hearing in a juvenile court shall not be used against any such child in any proceeding in any court other than as provided in code subsection 1615-9, which deals with the Street Gang Act, or 24-4-418 also deals with Street Gang Act. So obviously this does not have anything to do with gang or gang activity. So we would take issue that the state is able to actually use this juvenile history against my client at a adult proceeding, even with the conviction. So we would, with that being said, we would ask that the court do not use this against him far as sentencing is concerned. Outside of that, Judge, but if the court can recall, originally before the trial began, my client was attempting to take responsibility for this crime when we thought we had an agreement with the state. He was going to take 20 years. He immediately indicated he would take 20 years after my conversation with the prosecutor. So we was under the impression that we was going to have a negotiated plea. So what that indicates is that he was taking accountability, responsibility. His hands was tied when obviously they did not, well, we say they took it off the table, but it is what it is. But my client we believe my client as well has shown remorse, not only taking responsibility prior to the trial, but if you can recall, I don't know if the court can recall, but the jurors definitely noticed it in the conversation we had with them recently. I think that was Friday. Was that Friday? Or was that? The storm got my days mixed up.
Right, it was Monday.
Monday. All right, so.
I guess it was Tuesday. They deliberated all day Monday.
Yeah.
Tuesday, we had another hearing in here and they managed to have a verdict in the middle of that hearing. So you spoke with them Tuesday.
Yeah.
So a few days ago.
Right, and they noticed something that I didn't think they noticed. They noticed that my client was actually crying when Snow was testifying. When she was detailing what occurred, he was crying. So actually he have displayed remorse. In fact, he may have been trying to hide himself from crying, but the jurors obviously noticed that he was remorseful when she gave a detailed testimony as to when her fiance was actually shot. So we will argue that there have been remorse. First of all, we argue that he has attempted to take accountability. Secondly, we will argue that he has already displayed remorse. What we're asking the court, in light of the fact that the juvenile history we think should not be considered, then he has no history, no criminal history. And so here we are with a defendant with absolutely no criminal history, charged with and convicted felony murder and 2 other additional counts. But our thinking based on this history, because we know history is a very important part of sentencing. So if you have someone with no history, and the court has an option of life without parole or life with parole, it seems to me, Judge, that with someone who has no history should get the life with parole. And the person that has even one felony conviction, they would get the life without parole. Even circumstances that may not necessarily be true either. But certainly with someone that has no prior history, with one, and this is an unfortunate incident, but with one victim of a felony murder, we think that, just as my colleague indicated, the court is not granting him parole. He still has to go through the requirements that Department of Corrections require. It doesn't guarantee he's going to get parole, because they would do their due diligence to see if he qualifies for parole. So that's something that the court takes in consideration, that we can allow the Department of Corrections to make that final decision. But with that being said, we're asking for a sentence slightly different. On count one, we definitely ask for life with the possibility of parole. And the other two counts, as indicated by the state, we're asking that those years run concurrent, not consecutive. The amount of years we agree with, but we ask that it run concurrent with the life with parole. And then I just have one witness.
Okay, who's that?
Ms. Henderson, his mother.
Hello, Ms. Henderson. If you'll follow the deputy's directions, come on up to the podium, please.
And my client also want to say something after that.
I will definitely check with him before we wrap up your presentation.
I first want to start out by apologizing to Mr. Arnold's mother. I'm sorry this happened. I knew Mr. Arnold and Snow, they stayed next door to me. My dad used to take them to get food to the store, wherever they needed to go. I am truly sorry that this even happened. Judge Arnold, Kamaris had some challenges growing up in juvenile, but he overcame those challenges, and he was on the right track. Even when he was falsely accused and the state had to dismiss the charge on him. And after that, he came home and this happened. And I'm just asking that you have mercy on Kamaris and Demario. Please, Judge.
So, yeah. That's all she had.
Okay, thank you, Ms. Henderson. So we got to get Mr. Parks near a microphone. I'll let the deputies figure out how you want to work that. The microphones do not move.
You come right here, then. Counsel, you come right here. Okay.
Mr. Parks.
First of all, I would like to say I'm very sorry to Mr. Arnold mama. I didn't know this was going to happen. I didn't plan for this to happen. To be honest, to be 100%, I never I don't have no reason to want to buy his dead.
I want to be clear as we're working through this. I don't think there was ever any evidence that you or G or Mr. Phillips intentionally shot Mr. Arnold. He wasn't the target. He was standing in the wrong place. The way the bullet went through his body, it had to have come from where you and Mr. Phillips and G were at one point, as opposed to the mysterious location of the other people. But I'm not sitting here thinking that you thought for a second, that Mr. Arnold should be shot. I'm working through how many times you did shoot, at what you were shooting. And the tragedy is that Mr. Arnold, who had nothing to do with whatever beef was going on between the households, he was literally standing between them and got shot in the neck, and it killed him. So I don't think that he was intentionally shot, but he's dead.
I would like to say sorry to his mother behind that, but I most definitely have remorse for him. He died with something that didn't have nothing to do with him. But That's all I wanted to say. I just wanted to tell her I'm sorry because she said that we haven't showed any remorse. I just wanted to tell her I'm sorry.
Okay. Thank you, Mr. Parks.
That's all I have, Judge.
All right. So, Mr. Parks and Mr. Phillips, this day has been a long time coming. It is unfortunate that you had to sit in the county jail for so long to get your trial. No one should have to wait that long. That was nothing purposeful by any of the participants in the process, but that doesn't make it any better. But the longer we delay this outcome, the less fair it becomes for you two, for the lawyers trying to make your case, for Ms. Arnold and her family, frankly, for the state in trying to make their case. We all saw how hard it was. I guess Mr. Rowe finally tracked down Ms. Blankeny, but ideally we're handling these matters where maybe people have moved on, but they've moved on 6 months and not 2-3 years. And that's unfortunate. It casts problems into what is already a difficult situation that ought not to be there. I'm not going to engage too much on the different factual interpretations of what the evidence showed. It's not clear to me that this was an unplanned event. And I certainly would not refer to what ultimately happened as some set of mistakes by Mr. Parks, Mr. Phillips, and G. Whatever motivated the gunfire, whether it was in fact return gunfire, it's not clear to me that it was. It either was excessive self-defense or it was some retaliatory action on this household that was full of little kids. And it was clear to me in hearing from the local witnesses, so not a police officer or Mr. Jarvis or someone like that, but people who lived in that neighborhood, that everyone knew that in and around Ms. Henderson's place, there were lots of kids. And in and around the household that was shot up, there were lots of little kids. And that's what makes this extra scary. Firing shots in an uncontrolled way into a house that you know has people in it, whether they're old people or little people, there's no excuse or justification for that, that there was enough that was done that takes this far out of the realm of self-defense. The fact that the three sped off in the red car as opposed to staying to figure out, what the heck happened to Mr. Arnold, who I believe was not anyone's intended target. He's the casualty here. Suggests to me, tells me that there was more to this than just an unplanned event. And nothing good came out of this, but we are fortunate that the tragedy was limited, and it's a limitless tragedy for Ms. Arnold and her family. I don't mean to suggest that there was an okay outcome here, but that he's not buried next to 3 little kids who were in that house. And that could have easily happened because of what Mr. Phillips did and Mr. Parks did and G did. I'm not letting him off. I just don't have him in here. That being said, I'm also talking to 2 very young men. And I call you men because legally, by law, you're adults. But we learn more and more about how unformed and underformed and underdeveloped the human brain is, and the brain's ability to connect actions with consequences until you are healthily into your 20s. And again, that excuses nothing, it justifies nothing, but it ought to give someone in my position who is handing out the punishment that necessarily and appropriately goes hand in hand with killing someone and firing 30-something rounds into a neighborhood full of kids and their parents and caregivers, is some of what Mr. Rowe was getting to, but I actually combined Mr. Rowe and Mr. Monetas. Mr. Rowe says, don't look at what led up to this in terms of the difficult childhood someone had. And Mr. Menendez says you need to better understand how this person is coping with what's going on in his life and maybe making the very ill-informed and unwise decisions he made on that fateful afternoon in September of 2021. And I think it's actually appropriate to wrestle with the difficulties and setbacks and trauma that Mr. Phillips and Mr. Parks had as kids. Again, not because it makes anything better, but it helps everyone understand who it is we're looking at. We're not looking at a 40-year-old who had already been to jail once for shooting at someone and this and that. These are two young men who just was so clear they were unaware of. I mean, they're both aware because you know if you pull the trigger of a gun, a bullet comes out and bullets kill people. And clearly Mr. Phillips knew that given the losses he had experienced in his family. And I'm confident Mr. Parks knew that. But it's to Mr. Griner's point where people are literally skipping in the street, that it's almost like this is a real life video game. It's a little bit of GTA or Fortnite, but you just hit reset and everyone's okay at the end. But that's not what happens in real life. And there's no reset for either of you. You will get out of prison old and broken. You will not come out ready to be productive members of society. And that's the right outcome, given what you all did. But I do find, and I'll start with you, Mr. Parks, because we're going alphabetically, that the appropriate sentence for count 1 is a term of life imprisonment. Counts 2 and 3 are vacated by operation of law. Count 4 merges with count 1. Count 5 is 10 years to serve. That will run consecutive to count 1. And the final count for you, count 6, it has to be consecutive. I know Mr. Rowe wanted it to run concurrently, but legally it must run consecutive. And that will be consecutive to count 5. So it is a total sentence for Mr. Parks of life plus 15 years. Mr. Phillips, I'm going to pronounce it, but it's the same sentence, so you know going in. I don't view you as a party to the crime. I wasn't one of the jurors. I wasn't part of that discussion. And I do know the jurors were not privy to the shell casing information that shows that a third gun was firing throughout the situation. But either way, I'm not subscribing to the notion that this was an unplanned event and that either of any of the three, G, Parks, or Phillips, was just along for the ride. And so your sentence, Mr. Phillips, as to count 1 is life. Counts 2 and 3 are vacated. Count 4 merges with count 1. Count 5 is 10 years to serve consecutive to count 1. And count 6 is 5 years to serve consecutive to count 5 for a final sentence of life plus 15 years. You all can be seated. I have to tell you a few more things. You don't have to stand for that. And I want to be clear, this sentence doesn't fix things. It certainly doesn't bring Mr. Arnold back. Sentences don't ever do that. But it speaks that which needs to be spoken, which is you cannot, with impunity, shoot up a house in any neighborhood. There aren't neighborhoods where we just write them off and say, that's what happens in that neighborhood. It's okay because that's Notting Hill. It's not okay anywhere. It's not okay in my neighborhood. It's not okay in Ms. Henderson and Ms. Gates's neighborhood. Because this is what happens. A guy who's just standing there gets a shot through his neck and he's dead. Or, as Mr. Griner pointed out, it's a little kid. I mean, it could have been that guy dribbling a basketball. He could have been hit 3 times. He's down. He's dead. And I've got a mom and a dad in here saying, we didn't even see our kid graduate. At least Ms. Arnold, and she put it well, she had 31 years with Tobias. That's a long time. Now, you're entitled to more and you should have had more. And Mr. Tobias should be at your funeral and not the other way around. But Mr. Phillips and Mr. Parks and G did what they did, and we turned life on its head. But it doesn't bring Mr. Arnold back, and there isn't that pill or that chemistry set that would say, you know what, you had a tough childhood, Mr. Phillips and Mr. Parks. You ran a little wild as you were young, but let's do this and everything will be okay. We haven't figured that one out because we start too late. By the time you are here in court with me, it's too late because you've turned a curve and you've been charged with adult offenses, and they don't get more serious than this. and those have adult consequences. And while, as I said, you're legally adults, I'm quite confident that you haven't reached adulthood in terms of your ability to process what happens to you when you do something like you three did on September 13th. Mr. Parks and Mr. Phillips, I need you to listen to this part about your appellate rights. It ultimately will fall to your attorneys to handle this, but both of you have the right to a direct appeal to the Supreme Court of Georgia, to appeal any ruling I've made, to appeal your conviction, to appeal your sentence, and to challenge your lawyer's performance. I'm going to ask Mr. Menendez and Mr. Rowe to consult with you because you have 30 days from today to file either that notice of appeal saying, hey, Supreme Court, there were mistakes made and we want you to fix them. Or you can file a motion for new trial. And all that means is you're telling me, it actually starts here, Judge, mistakes were made by the prosecutor, by my lawyer, by the judge, and I make mistakes. And if we need to fix them, we fix them. And we argue that here in court, not right away, a ways down the road. And you may well have a different lawyer to help you with that. Because one thing that lawyer might do is look at how your lawyer performed to say, here was the real problem. It was because lawyer X didn't do this with this evidence. You need to pick one of the two. If you pick direct appeal, then it goes straight to the Supreme Court. If you pick motion for new trial, you get that. And if I deny it, you still get to go to the Supreme Court to have a lawyer argue for you that your conviction should be reversed, that the sentence was illegal, that there was some problem with the proceedings. You have to pick one of those within 30 days or you waive those rights. And if you cannot afford Mr. Rowe and Mr. Menendez for those appeals, because it's work, you have an absolute right to an attorney, and an attorney will be appointed to represent you for the motion for new trial and or that appeal to the Supreme Court. What Mr. Rowe and Mr. Menendez will need to do at a minimum, and again, it's fine if they stay on as your lawyer, if that's what you arrange with them, but within 30 days, they need to file one of those two things. If they don't, you've got your sentence and you will serve out your sentence. Mr. Parks, do you feel like you understand your appellate rights, that within 30 days, you need to have Mr. Rowe do one of those two things? Hey, I want a motion for new trial, or no, let's skip that. Let's go straight to the Supreme Court. Do you understand that?
I understand.
Okay, I'm gonna ask you and Mr. Rowe to talk about that. Mr. Phillips, same question. You understand that you've got a right to either have this motion for new trial filed, or you can skip it and go straight to the Supreme Court? Okay, you'll talk to Mr. Menendez about that? Okay.
Judge, I'm sorry, I don't mean to interrupt. My client has already indicated that he wanted to go ahead and get a court-appointed attorney regarding the appeal. I still filed the motion for new trial, Judge, but him and his family want me to ask.
Okay, so what I'll ask you to do is to file the placeholder motion for new trial.
All right.
And then file a motion to withdraw.
Okay.
Because that'll be the sign to me that then we'll get a lawyer appointed to represent Mr. Parks, who will then take over. There'll be plenty of time, as you know, and you can tell him that the deadline is that 30 days. Once that motion for new trial is filed, the lawyer coming in will have time. We don't even have a transcript of the trial, so it'll take a little while.
Okay.
Okay.
All right.
Mr. Greiner, I want to turn back to you. Anything you felt we did not cover that we need to get in the record as we close out the trial level proceedings in State versus Parks and Phillips?
No, Your Honor, I do disagree with my colleague in reference to the juvenile court histories coming in under 1511-703, but nothing further.
Okay. Mr. Rowe, you've already answered my question about whether there's anything else. It sounds like you'll take that final step in terms of your representation, get the placeholder motion for new trial in, and then we'll get a lawyer in place for Mr. Parks, and then we'll wait on that trial transcript.
That's all I have, Judge.
Okay. Mr. Menendez, anything else on behalf of Mr. Phillips?
Just, Your Honor, that I will file a motion for your trial on Monday, and that ethically I won't be representing him. I believe at this time he's indigent, so he would also require a court-appointed post-conviction attorney, although at any time he might retain counsel if his indigency changes.
Okay, will you file a motion to withdraw?
I was gonna ask the court about that. I don't know, there's different rules about that. Do I need to do that, or am I considered?
Well, I would, just because that's the signal I use to then reach out to the Georgia Public Defender Council to say, let's get an attorney in place for Mr. Phillips. And we'll need to see if it can be GPDC directly because of some of the conflicts that have been out there. But there will be a lawyer appointed to handle Mr. Phillips's appeal. It's helpful if there's the withdrawal filed because that's just the good trigger for us to get that going. Okay, great. Thank you. That's it. Thank you, everyone.
Thank you, Judge.
Ms. Rios, do we have something with Mr. Walker?
Jokes, but I'll just keep it up here.
Okay. This is position 6 on our plea and arraignment calendar. State versus Walker. It's 24 SC 003639. Mr. Walker is here in court, represented by Ms. Rios, who's disappeared. Oh, no, she's just right there.
Short.
Okay. Ms. Willingham is here for the state, and it's my understanding, Ms. Rios, that Mr. Walker is interested in going forward with a plea of some sort.
Yes, Your Honor.
Great. Mr. Walker, in just a moment, Ms. Willingham's going to put you under oath. Once you're under oath, please answer all her questions truthfully and let me know if you've got any questions of your own. Okay? Great.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name and your age.
Marquis Walker.
Are you now under the influence of any medicine, drugs?
You can put your hand down.
I'm sorry.
No, that's okay. Deputy, can you angle? No, I need you near the microphone. We'll angle the screen up. Yes, please, just so we get a little bit of Mr. Walker's face, because he'll be talking and we need, I think it actually, it can pivot. It's got a hinge there. Yeah, there you go. Great, perfect. All right, that way Ms. Rivers can see Mr. Walker. Back to you, Ms. Willingham.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I'm in my MBA program right now.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count 1 of this indictment, aggravated assault, would be null pros. You would be entering a plea to count 2, battery family violence, which has a minimum of 1 day and a maximum of 12 months. And your sentence would be 12 months probation. You are to complete the family violence intervention program, complete 30 hours of community service, have no weapons, no drugs, and no alcohol. And Your Honor, there is one matter that I'll get a little more into once we recite the facts, but the state is asking for no contact. I do recognize defense will ask for something different. And I think some of what I explained will kind of why the state will ultimately just leave it to the court to make
Okay.
the final
The victim
decision.
is on the Zoom.
Okay, well, we'll get through that. Can you, I got distracted. We had a visitor. It's how much probation?
12 months.
12 months probation.
Yes.
Okay, no contact with the victim.
Yes. Complete family violence intervention program.
Yep.
30 hours of community service.
Okay,
No weapons, no drugs, and no alcohol.
got it. Thank you.
Is this what was explained to you by your attorney?
Yes, ma'am.
You're pleading guilty today to battery family violence. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Well, I have a federal student loan case, but that's federal. Won't be done until May.
But tell me what that is. Are you on supervised release through?
No, not supervised release, just probation.
Okay.
Yeah.
You had a federal criminal case?
No, student loan. So I was I don't know what you want to call it. It's not even.
Student loan.
Yeah. They're unusual enrollment, but.
But how do they put you on probation for a student loan? I'm not following that.
That's what they.
Did you go to court?
Yes, I went to court
Where was court?
in Arkansas.
Okay. Was it a federal court you went to?
Yes.
And had they indicted you or?
I don't know how to.
Did you have a lawyer?
Yes, Miss Lacey,
And-
Latrice.
Okay, the name doesn't matter so much, but what was it that you were supposed to be doing that they were saying you hadn't been paying your loan back?
Yes, because I just jumped from university to university, so it's open.
Okay.
Yeah.
You gotta get in trouble for that.
Okay.
Right. Yeah. So.
Do you understand by pleading guilty today that your probation may be revoked? I have no idea about that kind of probation.
Yeah, so I'm at a loss too. I can't really, I don't give advice anyway from this position. Ms. Rios might be able to look something up. I don't think that this plea will affect probation related to a student loan unless when you were dealing with it, they said, hey, if you don't do X, you could go to prison.
Oh, no, it's not.
Because usually we don't lock people up for debts. That's not how it works. And so probation may mean more like it's hard for you to take out a new loan at a bank because there's a red flag in the system saying Mr. Walker needs to pay off his student debt before he can buy a new house or do something like that. But I'm guessing because I've never heard of it.
They just passed a fresh start, so they just put him back in deferment.
Okay.
Yeah.
You heard me tell the court what the negotiation is in this case, which is 12 months probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody? Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete family violence intervention program, complete 30 hours of community service, have no weapons, no drugs, and no alcohol. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes. Guilty with
Under
under Alfred.
Are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charged, but believe it's in your best interest to plead guilty today?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes.
Do you further understand that because this is a family violence conviction, that if you are found in possession of a firearm, you could be charged federally?
Yes.
Your Honor, should this case proceed to trial, the state would expect to show that on June 5th, 2023, a 911 call was placed by Elise Kania reporting being assaulted by her boyfriend at 2048 Bolton Road, Northwest Atlanta, Georgia, in Fulton County. Officers responded and took her report and documented her injuries. Detective Gruss was assigned the case to do follow-up investigation. The victim stated that she and her boyfriend, who was identified as Mr. Marquis Walker, had gotten into a disagreement regarding some sensitive information. The victim stated she began yelling and slammed her keys down on the counter, which upset Mr. Walker, who then proceeded to grab her by her neck and slammed her into the cabinet and then choked her to the point she could not breathe and was grasping for air while he was on top of her. She stated she could not even get the words out of her mouth to tell him to stop. The assault resulted in abrasions and redness to her neck as well as her back. The officer was able to pull Mr. Walker's ID based on the identifying information. The photo was then shown to the victim, who confirmed that he is the person who assaulted her and the person she lives with. Your Honor, the state is asking for no contact because in my initial communication with the victim, that is what she asked for. She initially asked that we dismiss the case. I explained to her the state would not be doing that. She said it happened so long ago. But she emphasized that even once the case resolved, she would want the court to make sure they explained to the defendant that she wanted no communication with him. So based on that, we were prepared to ask for no contact. We discussed with her a permanent protective order that I came over today prepared to have the defendant sign. And then my victim advocate also spoke with the victim. I believe Ms. Muhammad just stepped out, but she spoke with her. We got a call today saying that, again, she wanted to make sure that she really didn't want us to move forward with the case, but if we did, she wanted to make sure, or if we didn't, she still wanted to make sure that Your Honor would explain to the defendant that she wanted no contact and that she just wanted him to leave her alone. After we announced that we were going to likely be a plea, that we were going to discuss it, I ran over to get my binder. And when I came back, I was stopped because apparently the victim spoke with Ms. Rios and stated that she wanted no violent contact. I then stepped out with my victim advocate to call her again. During that call, she stated that it was very dangerous for her to be contacted while the defendant was present. She wasn't worried about it for her safety, but if that is how cases like this are handled, that is a very dangerous situation. She then explained.
I don't understand what you just said. It's dangerous for her to be contacted by you?
No, she felt that it was dangerous for the back and forth communication where the defendant was involved. And I understand that. It is my understanding during the conversation with Ms. Rios that the defendant was sitting there.
Okay.
So I understand that. But she also emphasized that it wasn't so much for her safety. Her concern was that if this is how these type of cases are handled, that drew concern for me, which is why I'm again asking for the no contact, because it's at this point a little unclear to me
what she really wants.
And unfortunately, kind of based on where we are, the offer was already extended, the defendant had already accepted. I'm not necessarily in a position to just revoke it.
Yep.
But I'm not quite sure whether or not this is a situation where I would be comfortable asking for no violent contact. I will say when my conversation with her ended, she did ask for no violent contact. I do believe that Ms. Rios provided her with the Zoom link, so
She's on. I can see her. I'm going to hear from her in a little bit. Okay. All right. I appreciate that. That's a rapidly evolving situation.
Yes.
We have Officer Tyson from pretrial. Could I hear from you before I turn to Ms. Kania? No, I see pretrial's on. Hey, pretrial. Good afternoon.
Good afternoon, Your Honor.
Hey, Ms. Tyson, how are you?
Hey, good. How are you?
All right. Do you have any criminal history information for Mr. Walker, position 6?
Yes. Looks like I have one arrest cycle out of Florida. That was from 2019, and that was for battery, touch, or strike. Looks like it was dismissed in August of 2019. He has 3 cycles out of the state of California from starting in 1999. Last arrest was in 2007. And that was for threatened crime with intent to terrorize. And it looks like that case, let's see, and battery with serious bodily injury. There's no disposition listed for that case.
Okay.
And he has 2 cycles out of Nevada. Last arrest was in 2012, and that was for felony theft. No disposition listed for that case either. Looks like he only had 1 misdemeanor conviction. That was from 2004 in Nevada, and that was for battery. Nothing to add, Your Honor.
All right. Thank you so much. That's our last case for the day. So you are free to go. Have a good weekend.
Thank you. You too, Your Honor.
All right. I want to make sure I'm pronouncing your name correctly, Ms. Kania. If you would unmute and tell me how to say your last name.
Kanya.
Kania. All right. I'm Judge McBurney. I appreciate you dialing in. So Mr. Walker is here to plead guilty, although he's going to explain through his lawyer why it's an offered plea. It sounds like if there was evidence of abrasions and redness on your neck, offered plea is not going to make a ton of sense, but I'll hear about that from Ms. Rios. What I really want to hear from you is the degree of contact you want to be able to have with Mr. Walker once he leaves this room, because he will be under sentence and I'll be setting the terms of the sentence. And I'll tell you, having heard about Florida and California and Nevada and now Georgia, I got my own thoughts, but you're living your life and I want to respect as best I can, consistent with my thoughts about your safety and security, your preferences.
No, I appreciate that. I would like the court to ask for no violent contact.
Okay. Can I ask you a few questions about your connection to Mr. Walker?
Go ahead. Sure.
How long had you known Mr. Walker before this incident in June of last year?
2 years.
You said a few or 2?
2 years.
2, okay. And at the time this happened, were you all sharing a residence or you were just in a relationship?
We were sharing a residence and a relationship.
Oh, how long had you been sharing a residence?
For about a year and a half.
Okay. Was it your place and you let him stay with you, his place, or you were both responsible for it financially and legally?
We were both responsible for it financially.
Okay. And were you working in June of 2023?
I was.
What did you do back then?
I am an executive assistant and project manager.
Okay. And was Mr. Walker working back then?
I believe he was.
Okay. Anything else you think I should know about you or Mr. Walker or that situation? I will certainly be hearing from Mr. Walker and his lawyer, and you're welcome to stay on the Zoom session. But I probably won't circle back to you. I want to make sure you've been able to express what you want to. I guess I have one more question and then anything you want to add. Why do you want to have contact with Mr. Walker after what happened on June 5th, 2023, what you told the police happened, what the photographic evidence suggests happened? Why is it that you want him in your life?
So prior to that, there was a year between this happening and Mr. Walker being arrested. And during that year, we had just been able to seek a lot of professional help, and we just didn't have we haven't had any other instances happen in our home.
Okay. Got it. Is it your expectation that when Mr. Walker is released from the conditions of his bond, he would return to your joint household, or you'll see how things go?
We'll see how things go.
Okay. I'm sorry, it probably sounds like I'm prying, but it's really for the important purpose of understanding where you're coming from, because it sounded like from Ms. Willingham, who is a consummate professional in her space of dealing with domestic violence situations, that your tenor had changed a little bit. And I was a little nervous for you that it changed because maybe you were receiving pressure from places you shouldn't as you were figuring out what you wanted to do. But it sounds like as a capable, competent adult, you're making your own decision about how you want this to move forward.
Yeah, I haven't received any pressure. It's, I think it was just a misunderstanding, but I definitely, just no violent contact, please.
Okay, thank you.
Thank you. May I please go back to work, or do I need to stay on?
That's 100% up to you.
Okay, all right. Thank you, guys. Have a great one.
Ms. Rios?
Yes, Your Honor. Mr. Walker is 40 years old. He's originally from Los Angeles, California. He's lived here since 2008. He has one son that's 18 years old who goes to Arizona Christian College and plays football. He works at Sparta Roofing as a sales project manager. He's been working there for 2 years. He attended Southern Poly and majored in business. He's currently at Western Governors University for his MBA in Identity Access Management.
Identity access management, that's my career path. Yeah.
I'm asking for you to accept the conditions that me and the state have negotiated. Mr. Walker's asking for no violent contact. And when I called Ms. Kania, I told her no pressure, just asking what you want, because it seemed to be unclear. He was shocked when I said, okay, we're about to sign a protective order. And he was like, what? No, I think they said they're going to counseling.
We've been doing, so what happened was we lost a baby. She lost her son at 16, which is in turn, she takes care of my son, like she treats my son like a son. Emotions were high, and we're not gonna go into there, but we lost a kid on Mother's Day. So that was that. And I have always took strides to better myself as well. I don't drink, I don't do any drugs, do community service, go to school and go to work. That's all I do.
Okay.
Asking you accept the plea is negotiated and do not no violent contact as Mr. Walker and Ms. Kania want.
What's the basis for the Alford plea?
We
changed to guilty.
Guilty plea?
Yes.
Okay. You've been in Georgia since, I think you said 07, 08?
2008. I came out here to play football.
Okay, but then we've got these arrests in Nevada in 2012.
Well, that's for 2004. So when they let me out on my condition as far as probation and things like that, I went to California and got a football scholarship, got my AA, and got a scholarship to go to Atlanta. So once, I never been in jail before. So once I got out, you have a warrant, and that's why I came back to 2012. So it's really from 2004. That's 20 years. So that case.
Okay, so it just wasn't resolved.
It wasn't resolved. There you go.
Okay, and where did you go to school here? You said
Clark, Atlanta. I went to Clark, Atlanta first to play football. And once I finished there, I went to Southern Poly, and that's when I played, which is Kennesaw State.
Okay. All right. Anything you want to add, Mr. Walker?
Like I said, we're couples counseling, doing everything that we're supposed to do. Like I said, that's an isolated incident. I understand what my previous history has been, but if I would have had a lawyer back then, those charges wouldn't. And I'm fully responsible to take care of my actions, or take responsibility for my actions. So my family, it's nothing but they're in the legal system. My younger sister's a detective. My godmother's gang intervention. I've been doing that since I was a little kid. So I mean, like I said, I don't want to hold up the court's time. We're very remorseful. Like I said, we're taking the steps to improve our relationship.
Okay. All right. Well, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. I will follow the semi-negotiated resolution. Count 1 is dismissed. Count 2 is 12 months probation. 3 special conditions to your probation, and they're called special because if you violate them, I can revoke all your probation. Non-special conditions, like you miss a meeting or something, it's not necessarily all your probation. Number 1, no violent contact with Ms. Kania. It's in some ways a non-condition because if you lay hands on her in the wrong way, it's a new charge anyway.
Don't go there.
But just so you know, that will also cost you all your probation in this case. So no violent contact with her. You'll need to complete the family violence intervention program. That's a long program. It's not one class, it's a bunch of classes. So plug in sooner rather than later, because probation will come to me and say, hey, it's been 4 months and this guy hasn't even started.
Let me ask you a question. Is that covered by the courts? Like or do I cover it? Yeah. As far as
You're asking who pays for it?
Yeah. So
Mr. Walker pays for it. But you're working in roofing, you're getting an MBA, you're going into identity access, so you're going to be fine paying for FVIP. And finally, you're going to do 40 hours of community service. That's a little bit more than what was negotiated, but it's no violent contact, not no contact. And that community service, you are tuned into that. It does not mean picking up trash on the side of the road.
No,
if you work with probation and say, here's how I give back, whether it's gang intervention, I'm at an at promise center, whatever works, as long as it's documented, but not documented by a relative of yours. But I'm Fred Smith and Mr. Walker was here. That community service can be anything that gives back to the community. Just work with your probation officer, and as long as they sign off and say, oh, that's a great program, go for it, you knock out your 40 hours, no issue. Ms. Willingham, anything else in Mr. Walker's case?
Nothing from the site.
Thank you for working with everyone on this. Ms. Rios, anything else?
No, Your Honor.
Ms. Willingham, is it all right if someone in my office signs the indictment on your behalf?
Yes.
Ms. Rios?
Yes, sir.
And Mr. Walker, we can sign for you?
Yes.
We'll do that. You're going to get information from Ms. Rios about how to connect with misdemeanor probation. It may just be telephonic, and you never have to go and meet with them. Their office is half a block from here, just so you know. If they say come on down, it means basically coming down to the courthouse, but there's a low rise near here. But you'll just need to follow their direction. Okay?
Yes, sir.
All right. That's it.
Thank you.
Thank you, Your Honor.
Hey. Okay. Yeah, email address, phone number.
So are you a Clark Atlanta person or a Southern Poly, or you guys are in the same fraternity? Same fraternity.
Yeah.
Okay.
I went to Savannah State.
Got it.
So my freshman year, I went to school they told a new store. I went to school with me. I ended up transferred after my freshman year and just next Savannah State.
Great.
So I majored in Homeland Security and Emergency Management with a minor in criminal justice.
Wow. Look at all that stuff. Good.
Yeah.
We had something.
I thought about going to Texas because Georgia doesn't really. It seems like all the good Homeland Security jobs are in Texas.
Yeah.
For obvious reasons.
Yeah.
So, I mean,
Right. Border.
Yeah. So I was like, it's kind of weird how I became law enforcement. I actually was doing armed security for Bank of America, and I met this APD officer. He always came to my bank. So he was like, "What you think about policing?" And I was like, "Man, I never thought about being policing." And so gave him my resume. Within like a week, I got a call. He was like, "Come down to the police headquarters." Came down there, did the polygraph, knocked everything out one day, man. Like the next week, I was in the academy.
Wow. Good for you.
Yeah.
All right. Well, we're glad you're here.
Yes, sir. So, yeah.
All right, Ms. Rivers and Officer Evans and Ms. Nelson, I think we're done. I've got a Zoom thing later, but it's civil and I'll do it from my office. Thank you. It was a crazy week. You guys have a good weekend.
You too, Judge. Have a good weekend.
Bye.